Assalamualaikum everyone. My name is Rani Atira binti Ismail.
My name is Nur Hanani Afikah binti Eraza.
My name is Nur Shazwani binti Zainuddin.
My name is Nur Shafia binti Muhammad Fazil.
My name is Nurin Jazina.
Let's start with the employment history of the claimant Chang Chen-hua. He started working at the South Island Plastic on the 1st July 1983 and served the company for about 37 years as a director and was directly supervised by the managing director Tan Ko Aoi. He was given an employer number 10,002, received a regular monthly salary, EPF contributions were deducted from the beginning. He was also included in the company employment records. Although there were no written contract, the way the company treated him for many years created an implied contract of service. This shows that an employer and employee relationships does exist. Now, let's look at the corporate acquisition in 2020. On 17 February 2020, South Island Plastic was acquired by Magnitech Industry Berhad and become its wholly owned subsidiary. After the acquisition, the claimant was promoted from working director to managing director while still remaining a board director, which means he held dual roles. Next, I will explain the facts leading to the dispute. Before I go into details, there are 3 key points to understand. First, the dismissal was done without just cause under the Industrial Relations Act. Second, the company acted in bad faith. Third, it was part of the contract-related removal scheme. The dispute began when the company removed the claimant from the board of directors through an ordinary resolution. Under company law, directors can be legally removed this way. After removing him from the board, the company then dismissed him from his positions as a managing director. The company justified this by stating that the managing director must also be a director on the board of directors. At the same time, the company attempted to change the claimant's status from a permanent employee to a fixed-term contract. However, no clear reason for this change was provided in the judgment. The claimant rejected the proposal because he believed that he was still a permanent employee. His refusal became the main trigger for the company's actions. As a result, the dismissal was done in a bad faith and without just cause under the Industrial Relations Act. Now, let's look at the parties involved. There are 4 main parties in this case. First, the claimant is Chang Chen-hua, the former managing director who claimed an employer and employee relationships and filed an unfair dismissal case. Second, the respondent is South Island Plastic Sedan Berhad, the company that terminated his employment and is directly responsible for the dismissal. Third, the parent company is Magnitech Industry Berhad, which owns 100% of South Island Plastic but does not employ the claimant directly. Fourth, the legal representative are for the claimant Lee Kang-keng and Nurul Hidayah Harun. For the respondent, Leo Tatfa and Leo Min Shiwan.
Today, I will be presenting the 4 key legal issues that court had to consider in this dismissal case. So, the first issue, whether the claimant was an employee or a workman. This is the foundation of the entire case. A person can only bring a dismissal claim if he is legally recognized as a workman under Section 2 of the Industrial Relations Act 1967. The company argued that the claimant was only a director and therefore not protected by employment law. However, the claimant showed clear evidence that he had been working employee for about 37 years. He received a monthly salary, EPF deductions, and performed day-to-day operational duties just like any other employer. So, even though he was a director, he also functioned as an employee. The court had to determine which view was legally correct. Second issue, if he was an employee, was determination done without just cause and excuse? Once employee status is established, the next question is whether the dismissal was fair. The court examined several points. First, whether the dismissal was actually driven by family conflict, not performance issue. Second, whether the company pressured him by asking him to sign a fixed contract instead of keeping him as a permanent employee. Third, whether the company's claim of 10 years of poor performance or just made up later to justify firing him. Lastly, whether removing him through the company's article was just a shortcut to bypass proper employment procedures. The court examined whether this accusation were properly documented, whether any warning letters were issued, and whether due processes was followed before termination. The third issue, did the company have valid reasons for the dismissal? The company accused the claimant of several forms of misconduct. First, having a passive attitude. Second, resisting new changes in the company. Third, causing weak revenue growth. Fourth, conflict of interest. And lastly, allowing his son's misconduct. The court examined whether these accusations were properly documented, whether any warning letters were issued, and whether due processes was followed before termination. Fourth issue, if the dismissal was unjust, what remedy should be given? The final issues concern the appropriate remedy. So, the claimant was already 65 years old and close to retirement. Because of that, reinstatement might not be practical or beneficial for either party. So, the court had to consider several factors. First one, his long 37 of service. Second, whether trust between both sides had already broken. Third, whether reinstatement would be unrealistic. And lastly, whether monetary compensation would be a fairer solution. In many cases involving employees close to retirement, compensation is considered more suitable.
And I will explain the law and the legal principle applied in this case. Issue 1 is whether the claimant was an employee. Under Section 2, Industrial Relations Act 1967, a contract of service may be oral, written, or implied from conduct. The claimant received monthly salary with EFPF deduction, continuous EA form, and employee number, and performed daily operational duties as managing director. In Tevigan vs. Kumpulan Act and Amir Al-Zaharib vs. Eco-Varied Packaging, the court held that the salary payment and workplace conduct prove employment even without a written contract. Therefore, the claimant was legally an employee. Issue 2 is whether the dismissal was unjust. Under Section 20(1) Industrial Relations Act 1967, the employer must prove that dismissal was genuine based on valid reason and supported by evidence. Here, no warning letter, no disciplinary process, no document, and no performance appraisal was produced. Under afterthought allegation doctrine, the reasons raised after dismissal are rejected. In Gon Kui Poi vs. JMP Code and Sabah Forest Industry, the court required documentary proof of misconduct or poor performance. As none existed, the dismissal was unjust. Issue 3 concerns justification for dismissal. Under Section 20(1) Industrial Relations Act 1967, the employer must prove dismissal was for just cause and excuse. This requires valid reason and proper procedure, including warnings and disciplinary inquiries. None of these steps were taken in this case. Based on Guan Kipoi and Sabah Forest Industry, failure to prove both substance and procedure means dismissal is unjust. Therefore, the termination was not justified. Issue 4 is the remedy. Under Section 20, Industrial Relations Act 1967, reinstatement is the main remedy, but Section 30(5) allows refusal where it is impractical. The claimant was 65 years old beyond retirement age, so reinstatement was refused. Cases of Hong Leong Equipment and Dr. James Alfred limit remedies where reinstatement is impractical. Therefore, the court awarded back wages only, with no reinstatement or compensation.
decision made by the court was regarding the employee status of the claimant. The court ruled that the claimant was recognized as an employee under the Industrial Relation Act 1967, even though there was no written employment contract. The court emphasized that even without a writing contract, an oral or implied contract can still exist. In this case, the court looked at evidence such as salary payment and statutory deduction like EPF and SOSO, which were made by the company. Therefore, the court concluded that the claimant was indeed a workman based on the company practice of paying wages and making statutory deduction. Next, the court examined the dismissal of the claimant by the company. The company claimed that the dismissal was due to poor performance, but the court found that there was insufficient evidence to support this claim. No warning letter or show cause letter were issued to give the claimant a chance to improve his performance. Therefore, the court decided the claimant dismissal was without just cause or excuse, as the company allegation were not supported by clear evidence. Finally, the court considered the remedy or compensation awarded to the claimant. The claimant requested restatement to his original position, but the court found that the claimant was 5 years old, exceeding the mandatory retirement age of 60. Therefore, restatement was not allowed. As a replacement, the court decided to award back wage for 24 months, totaling 552,000 ringgit. Additionally, the court followed the principle that if there is no evidence of post-dismissal earning, no deduction will be made from the back wage.
So we move to the last part, which is lesson learned. On this slide, we learn that a managing director or an executive director can still be considered an employee. This happens when the person receives a salary, contribute to EPF or so, is under the company's control and perform daily operational duties like any normal staff. The key significance is that a company cannot simply deny someone's employee status just by calling them a director. What truly matters is the actual working relationship, not the job title. Okay, so for this part, they explain no written contract does not remove employment relationship. A contract of service still can exist through oral agreement, the conduct between both parties, and supporting documents such as EA forms, payslip, or EPF and SOSO records. The key is significant that employers cannot use the excuse of no appointment letters to deny an employee status. If the working relationship exists in practice, then employment still legally exists. Here, the lesson learned is that dismissal must always be supported by valid and fair reasons. In this case, the employer claimed poor performance, but there were no warning letters, no performance records, and the so-called reasons only appeared after the termination. This shows that employer must follow proper HR procedure with proper documentation. Failure to do so result is an unfair dismissal claim.